Good morning, brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, officers, officials, listener learners. I welcome all respected doctors and directors. I welcome all honorable ministers, managers. I welcome all adorable administrator, advisor, advocates. I welcome the most honorable present Prime Minister Modi ji. It is really nice time, nice place, nice action that we are describing, explaining, defining our holy Indian spiritual, cultural, educational, and even constitutional identities in the form of unity in diversity. State of succession. State succession, its definition and meaning of state succession. A succession of government occurs when the government of a state is replaced with a new one. State succession occurs when a state ceases to exist or new state is formed within the territory of an existing state or territory is transferred from one state to another state. When a succession situation arises, the point of chief legal interest is the effect, if any, on the international rights and obligations of the state or states concerned. According to Oppenheim, a succession of international persons occurs when one or more international persons take place of another international person in consequence of certain changes in the latter's condition. The rule of state succession was incorporated from the Roman law by Grotius. In Roman law, when a person dies, his rights and duties are succeeded by his successors. This principle was applied by Grotius in international law as well. Later on, there were certain international treaties through which the rules of state succession were dwelt. The law of state succession is still developing. Now let's go to the term state succession misnomer. According to T.D. Paulos, under traditional rules of international law, the term state succession is used when there is transmission of the rights and obligations of one state to another in consequence of territorial sovereignty. Further, the term state succession has been regarded as inaccurate because it is based on municipal law analogy of the actual demise of a person and the transmission of his rights and liabilities to his successor, used by classical international law writers like Gentils, Grotius, Offendorf, and Vattel. BPO Connell also writes the term state succession has been objected to as begging the question which any investigation of the consequences of chain of sovereignty seeks to resolve. It seems to suggest that the state which extends its sovereignty over a specific territory thereby becomes invested with all the judicial consequences of its predecessor's acts. That is, in law as well as in fact, the later succession. The significance of the term is to be limited. However, to the actual situation which arises when one state is substituted for another in sovereignty over a given territory, and in this sense it enjoys the authority of an extensive nature. It does not necessarily presuppose a judicial substitution of the acquiring state in the complex of rights and duties possessed by the previous sovereign. Ordinarily, the practice of states shows that no general succession takes place. With the extinction of international person, disappear its rights and duties as a person. This seems to be correct to a great extent, but to say that no succession takes place among the states would not be correct. Most of the jurists agrees that when an international person extincts or disappears when some of its rights and obligations are succeeded by other international persons which take place, there is, however, controversy and uncertainty as to which rights and duties devolve on the successor. Kinds of state succession. State succession are of two types. One is universal succession and two is partial succession. If the legal identity of a community is completely destroyed, there is said to be a total succession of states. If the territory is lost while personality and legal responsibility remain unimpaired, the process is described as partial succession. This does not imply a total or partial succession respectively to the legal relation of the previous sovereign, but is merely an abbreviated way of defining the extent of the change. What is universal succession? Universal succession takes place under circumstances when one state is completely absorbed in another state, either through subjugation or voluntary merger. When a state breaks into several parts and each part becomes a separate international person or are annexed by surrounding international person. Partial succession. Partial succession takes place when a part of the state revolts and after achieving freedom becomes a separate international person. The breaking away of Bangladesh and becoming international person is a glaring example of partial succession. A part of state may also become independent through agreement or any other peaceful means. When a part of a state is ceded to another state, when a sovereign state loses a part of its independence by joining the federal state or when a state accepts the suzerainty or becomes a protectorate of another state. Principle of the continuity of states. The succession of governments is based on the principle of the continuity of states. The change in the government of a state does not affect the legal personality of the state. The new government succeeds to the rights and obligations of the predecessor government. This principle is based on the common interest of international community. The importance of international agreements will suffer a setback in case one treaty obligations are disregarded in consequence of the change of government of a state. But the treaties entered into by a state come to an end in case it is completely absorbed in another state. This rule also applies in a case when a part of state revolts and after becoming an international person refuses to follow the treaties entered by its parent state. For example, Bangladesh is not bound by the treaties entered into by Pakistan. Reference may be made here to the Toronto arbitration. Great Britain, Costa Rica 1923, wherein in January 1917, the government of Costa Rica under President Alfredo Gonzalez, Gonzalez was overthrown by Federico Tonico, the Secretary of War. Gonzalez fired Tinoco assumed power, held an election, and established a new constitution in June 1917. His government continued until August 1999. When Tinoco retired left the country, his government fell in September following after a provisional government under one Barclay. The old constitution was restored and elections were held under it. The restored, the restored government was a signatory to this treaty of arbitration. On the 22nd of August 1922, the Constitutional Congress of the restored Costa Rican government passed a law known as Law of Nullities number 41. It invalidated all contracts between the executive power and private persons made with or without approval of the legislative power between January 27, 1919 and September 2, 1919. Covering the period of the Tinoco government, it also nullified the legislative decree number 12 of the Tinoco government, dated June 28, 1919, authorizing the issue of the 15 million columns, 15 million columns currency notes. Great Britain claimed that the Royal Bank of Canada and the Central Costa Rica Petroleum Company were British corporations whose shares were owned by British subjects, that the Banco International of Costa Rica and the government of Costa Rica were both indebted to the Royal Bank in the sum of 998,000 colons, evidenced by 1999, 998, 1,000 bills held by the bank that the Central Costa Rica Petroleum Company owned by due assignment, a grant by the Tinoco government in 1918 of the right to explore for and exploit oil deposits in Costa Rica, and that both the indebtedness and the concession have been annulled without right by the law of nullities and should be expected from its operation. She asked for an award that she was entitled on behalf of her subject to have the claim of the bank paid and the concession recognized and given effect by the Costa Rican government. The government of Costa Rica denied its liability for the acts or obligations of the Orinoco. The government of Costa Rica denied its liability for the acts or obligations of the Orinoco. Government and maintained that the law of nullities was a legitimate exercise of its legislative government power. It further denied the validity of such claims on the merits unaffected by the law of nullities. विदेश मंत्री डॉक्टर जयशंकर ने आर्मीनिया का जताया आभार। ईंधन उपलब्धता के लिए सरकार का हर संभव प्रयास जारी। सरस्वती मां भद्रा महामाया वर्त भद्रा। केंद्र सरकार ने पैनिक वाइन से बचने की दी सलाह। हिमाचल प्रदेश कुल्लू में बस हादसा 4 की मौत 14 घायल। विधानसभा चुनाव 5 राज्यों में धुआंधार प्रचार जारी। पीएम आज कूच बिहार में करेंगे चुनाव रैली पश्चिम बंगाल। टीएमसी नेता अभिषेक बनर्जी की कई जनसभाएं पश्चिम बंगाल। ट्रंप का ईरान को 48 घंटे में हॉर्मुज स्ट्रेट खोलने। ईरान ने राष्ट्रपति ट्रंप के अल्टीमेटम को किया खारिज। ईरान में फंसे 345 भारतीय मछुआरे सुरक्षित पहुंचे स्वदेश। विदेश मंत्री डॉक्टर जयशंकर ने आर्मेनिया का जताया आभार। ईंधन उपलब्धता के लिए सरकार का हर संभव प्रयास जारी। केंद्र सरकार ने पैनिक बाइंग से बचने की दी सलाह। कुल्लू में बस हादसा 4 की मौत घायल। हिमाचल प्रदेश 5 राज्यों में धुआंधार प्रचार जारी। विधानसभा चुनाव। पीएम आज कूच बिहार में करेंगे चुनाव रैली पश्चिम बंगाल। टीएमसी नेता अभिषेक बनर्जी की कई जनसभाएं पश्चिम बंगाल। ट्रंप का ईरान को 48 घंटे में हॉर्मुज स्ट्रेट खोलने का ऐलान। ईरान ने राष्ट्रपति ट्रंप के अल्टीमेटम को किया खारिज। ईरान में फंसे 345 भारतीय मछुआरे सुरक्षित पहुंचे स्वदेश। विदेश मंत्री डॉक्टर जयशंकर ने आर्मेनिया का जताया आभार। ईंधन उपलब्धता के लिए सरकार का हर संभव प्रयास जारी। केंद्र सरकार ने पैनिक बाइंग से बचने की दी सलाह। कुल्लू में सहसा 4 की मौत 14 घायल। हिमाचल प्रदेश। William H. Taft, arbitrator, held that the law of nullities in decreasing in determining the invalidity of the Amori concession worked no injury to the Central Costa Rica Petroleum Company Limited. Its sole stockholder, of which Great Britain can complain because the concession was in fact invalid under the Constitution of 1917. Expounding the law on the subject, he observed, the courts of the restored government are bound to administer the law of the restored government under its constitution, and their decisions are necessarily affected by the limitation of that instrument. This may prevent the court from giving full effect to international law that may be at variance with the municipal law, which under the restored constitution the national courts have to administer. It is obvious that the obligation of a restored government for the acts of the usurping de facto government, if succeeds, cannot, from the international standpoint, be prejudiced by a constitution which though is sought to light is for the purpose of this discussion. Exactly as if it were new legislation which was not enforced when the obligations arose, Mr. Taft, arbitrator, quoted with approval the following observation of Dr. J. B. Moore. Changes in the government or the international policy of a state do not as a rule affect its position in international law. A monarchy may be transformed into a republic or a republic into a monarchy. Absolute principles may be substituted for constitutional or the reserve, but through the government changes, the nation remains with rights and obligations unimpaired. Further, the principle of continuity of states has important results. The state is bound by engagements entered into by governments that have ceased to exist. The restored government is generally liable for the acts of the usurper. The origin and the organization of government are questions generally of the international discussion and decision. While powers being with the existing de facto government when sufficiently established to give reasonable assurance of its permanence and of the acquiescence of those who constitute the state in its ability to maintain itself and discharge its internal duties and its external obligation. According to Mr. Taft, this statement of law announces a general principle which has had such universal acquisitions as to become well settled international law. Theories of state succession. Professor D.P. O'Connell classifies the theories of state succession into the following categories. One is theories of continuity, two is negative theory, three is theories importing international law, four is communist theory of state succession. Theories of continuity. The theory of universal succession. According to this theory, change of rules, whether effected by succession of territory, by revolution or by death, cannot involve the replacement of one right to duty by another, but only a replacement of their subjects. If a ruler acts in a private capacity, his contracts expire with his death or expulsion. But if he acts in his princely office, his comments relate not to himself, but to people through whom, in virtue of social contact, he ultimately derives his authority. This theory was in vogue up to the middle of the 19th century. According to this theory, succession takes place by virtue of a legal principle antecedent to the enacted law of any society and therefore antecedent to the positive law of nation. But it may be noted that succession occurs not in virtue of an external legal prescription, but in virtue of a legal quality which reposes in the objects of succession, the theory of popular continuity. According to this theory, change of sovereignty involves no more than a change in the felicitous element in political organization, the real element surviving in it. Obligation of a political character, such as treaties, attain to the eternal of element of sovereignty and lives within. Obligations of a patrimonial character, including most economic and judicial matters attached to society and remain attached. Thus, while the emphasis in this theory is upon legal continuity, therefore, the degree of continuity actually achieved is, in virtue of this transformation, considerably less than that achieved in the theory of universal succession, the theory of organic substitution. This theory emphasizes more the nature of change itself than the legal effects of political change. When states appear and disappear, the people and territory are integrated in a new organic being. There is a change in the judicial element of organization, which does not occur in cases of change of government. The legal institution, which attach to the actual elements, survive the change while those which attach to the organizational element do not survive it. This theory does not radically differ with the preceding ones in the words of B.P. O'Connell. This means that the successor state takes over all the rights and duties of its predecessor, save those which are essentially political. If it substitutes itself effectually in the property of its predecessor, it must also substitute itself in the encumbrances upon the property. The theory of self-abnegation, the state is at liberty to take over or reject whatever suits it in the previous legal order. It integrates within its own legal order all existing law which is compatible therewith and which is not expressly repealed. This theory emphasizes the continuity rather than disruption and constructs the legal bonds of continuity on the basis of tacit consent of all the parties concerned. Negative theory, since the universal succession theory did not take into account the existing facts of international practice, negative theories were developed during the later half of the 19th century and early part of the 20th century. According to these theories, the sovereignty of the producer state over the absorbed territory is abandoned. House is thus created between the expulsion of one sovereignty and the extension of the other. The successor state does not exercise its jurisdiction over the temporary in virtue of a transfer of power from the predecessor, but society, because it has acquired the possibility of expanding its own sovereignty in the manner dictated by its own will. None of the incidences of sovereignty passes to the successor state. The latter seizes what it can and repudiates with what it will. It is important international law. According to this theory, international law, based on the positive practice of state, directs the successor state to discharge certain of its predecessor's obligation and vest in it certain of its predecessor's rights. The approach is useful with respect to the effect of change of sovereignty on relationships governed by international law, such as treaties, and indeed, it may be the only feasible approach with respect to them, but it is quite irrelevant to the solution of problems raised by change of sovereignty with respect to relationship governed exclusively by municipal law and even of the problem of the survival of that law itself. Communist theory of state succession. The main emphasis under this theory is that the successor state is unencumbered by the economic and political commitments of the producer. In its conclusion, we can say Professor B.P. O'Connell has rightly concluded the law of state succession in the mid 20th century has reached a position of crisis because evident moral and sociological pressures emphasize the need for continuity and avoidance of disruption, while theory remained invest in the 19th century conception of sovereign will. The problem is to give expression in normative form to reconciliation of two competitive pressures, that of stability in the international and internal orders, and that of adjustment of legal relationship to the social and economic effect of change. The solution lies in a presumption of continuity which concrete analysis may revert. ईरान ने ट्रंप को अल्टीमेटम को किया खारिज। राष्ट्रपति ट्रंप ने ईरान को 48 घंटे की दी चेतावनी। पश्चिम बंगाल आज राष्ट्रपति ट्रंप ने हॉर्मुज स्ट्रेट को खोलने की दी थी डेडलाइन। अमेरिका ईरान में महासंग्राम। ईरान ने अमेरिकी राष्ट्रपति की इस बड़ी धमकी को नकारा। धमकी का मतलब ट्रंप के लिए जहन्नुम के खुले गए दरवाजे। जनरली अब्दुल्ली ट्रंप का यह बयान पूरी तरह महत्वपूर्ण। ईरान की ऊर्जा संयंत्र। ईरान में फंसे 315 भारतीय मछुआरे सुरक्षित वापस। ईरान के अंदर अमेरिकी वायुसेना का बड़ा ऑपरेशन। कई ईरानी सैन्य नेताओं का खात्मा। ट्रंप से अमेरिका ने हमले में ईरान के कई कमांडर ढेर होने का किया दावा। ईंधन उपलब्धता। केंद्र सरकार ने पैनिक बाइंग से बचने की दी सलाह। वीडियो में भीषण धमाकों लड़ाकू विमानों का शोर तेहरान भर से ट्रंप कई ईरानी सैन्य नेताओं का खात्मा। हमने ईरान के अक्षम सैन्य नेतृत्व को खत्म किया। ट्रंप से युद्ध भड़काने में थे शामिल ये लोग। डोनाल्ड से पश्चिम बंगाल पीएम आज कूच बिहार में करेंगे दौरा। टीएमसी नेता अभिषेक बनर्जी की कई जनसभाएं पश्चिम बंगाल। ट्रंप का ऐलान को 48 घंटे में हॉर्मुज स्ट्रेट खोलने का अल्टीमेटम। भारत की सफल कूटनीति। भारतीय मछुआरों को आर्मेनिया के रास्ते से निकाला। आर्मेनिया के रास्ते मछुआरों को भारत लाया गया। ईरान में फंसे 345 भारतीय मछुआरे सुरक्षित पहुंचे। विदेश मंत्री सहयोग के लिए आर्मेनिया सरकार का बहुत धन्यवाद। भारत की सफल कूटनीति। ईरान में फंसे 345 मछुआरे भारत पहुंचे। पश्चिमी एशिया के खराब हालात पर नजर रख रहा है विदेश मंत्रालय। केंद्र सरकार ने पैनिक बाइंग से बचने की दी सलाह। मध्य प्रदेश कुल्लू में बस हादसा 4 की मौत 14 घायल। Rights and duties arising out of state succession. When an international person takes the place of another international person, following rights and duties arise. Political rights and duties. No succession takes place in respect of political duties and rights. As remarked by Professor Oppenheim, no succession takes place thereof with regard to rights and duties of the extinct state arising either from the character of later as an international person or from its purely political treaty. I thank all my brothers and sisters ladies and gentlemen, students, scholar, teacher, trainer, professor, listeners, officer, officials. I thank all respected doctors and directors. I thank all honorable ministry managers. I thank all honorable advocates and ministry advisors. I thank the most honorable President. Thank you very much. I see all of you. Thank you.